Hello, my good friends, my Patriot friends. This is Caleb. I am overjoyed to be with you again. And this evening, we've got a special release. As I have several interviews coming up, I'd like to record this show in advance so that it might be shown based upon Patriot Soapbox availability. I do greatly appreciate you coming tonight, and I will show you the context of this meeting. And you're going to find that it really is earth-shattering, and I look forward to doing the following. Number one, I'd like to investigate some of the issues surrounding the FISA court and how those interests were avoided, played, um, and manipulated through use of the NSA documents and the NSA website. And additionally, after that, I would like to break into a segment that will show us, as my previous shows have indicated, the Roman Empire determined that they must conquer England, and they installed a Holy Roman Elector in 1714 in place of other family members that were more closely related. Because this person was immensely important in that this king had the title of Holy Roman Elector, so they moved the Holy Roman Empire title to England in that year. Additionally, this person, which I found out, I thought it was irrelevant. However, it was the largest portion of why they moved this person into the monarchy in 1714, because this person was from Germany. And I will show you why that's important coming up. Let me get busy with showing you some information. I will immediately start sharing some things with you. Bear with me for a moment. This is NSA's website, NSA CSS, a Central Security Service. If you don't know the difference, it's very important to understand this distinction between the two. Mission and values of NSA, the National Security Agency, Central Security Service, NSA CSS, leads the U.S. government in cryptology that encompasses both signals intelligence, SIGINT, and information assurance, now referred to as cybersecurity, products and services, and enables computer network operations, CNO, in order to gain a decision advantage for the nation and our allies under all circumstances. Core values are commitment to service, respect for law, integrity, transparency, respect for people, and accountability. As you can see, these core values reflect our current concerns in our government for the lack thereof: respect of law, respect of transparency, respect of people, respect of privacy, and I continue. The CSS, and if I may go back to the CSS, what the CSS is about. The Central Security Service provides timely and accurate cryptologic support, knowledge, and assistance to the military cryptologic community. It promotes full partnership between the NSA and cryptologic elements of the armed forces, and teams with senior military and civilian leaders to address and act on critical military-related issues in support of national and tactical intelligence objectives. CSS coordinates and develops policy and guidance on the signals intelligence and cybersecurity missions of NSA/CSS to ensure military integration. The CSS was established by Presidential Directive in 1972 to promote full partnership between the NSA and service cryptologic components of the U.S. Armed Forces. The new command created a more unified cryptologic effort by combining NSA and CSS. The director of NSA is dual-hatted as the chief of CSS. The principal advisor to Director NSA/Chief CSS on military cryptologic issues is the Deputy Chief CSS DCH CSS. The DCH CSS oversees the function of the military cryptology system, manages and cultivates the partnerships between NSA/CSS and service cryptologic elements, and ensures military capabilities to fulfill the national cryptologic strategy. As we see, this is significantly important with regard to Q, as we find our military cryptologic assets are supporting POTUS's efforts, and that is done through this cooperative agreement with CSS. Now, how did this turn sour? Well, we will find that whoever oversees these departments are the members that have the capacity to change things. Although NSA has its own emblem for many years, CSS did not in 1996. Director NSA Chief CSS Lieutenant General Kenneth A. Minahan, U.S. Air Force, requested an insignia be created to represent both the National Security Agency and the Central Security Service. As a result, a CSS seal was designed and adopted that year. Today, the emblem displays all 5 service cryptologic components, which are comprised of the United States Fleet Cyber Command, the United States Marine Corps Director of Intelligence, the United States Army's Intelligence and Security Command, the 25th Air Force, and the U.S. Coast Guard Deputy Assistant Commandant for Intelligence. Each are equally balanced around a 5-point star on which is centered the symbol of NSA/CSS, who provides the funding, direction, and guidance to all America's SIGINT activities. So we've met the NSA and CSS. What about transparency? Well, that's what we need going forward. So we're wondering, what about transparency? So I'm going to go ahead and search this site for transparency and see what it produces. Oh, the NSA assigned its first transparency officer. Now you can see I've previously clicked on this, so it's no surprise for me. I apologize for doing that just for the effect. Okay, this was April 11th, 2016. Rebecca Richards, NSA's Director of Civil Liberties and Privacy, has been appointed to serve concurrently as the agency's first transparency officer. This dual role complements ongoing initiatives to ensure that NSA has the best civil liberties and privacy practices. The appointments reflect NSA's commitment to the principles of intelligence transparency for the intelligence community, IC, which were recently established by the Office of the Director of National Intelligence in conjunction with the IC. The principles support making information publicly available in a way that enhances understanding of intelligence activities, while continuing to protect information when disclosure would harm national security. You can view the principles at www.dni.gov, but that link does not work. It takes you to a server not found. As the NSA Transparency Officer, Ms. Richards will serve on the ODNI-led Intelligence Transparency Council, a new forum where the IC will develop a strategic, coordinated, and proactive approach to increase transparency. This approach will include not only sharing information about the rules that apply to the IC and its compliance under those rules, but also sharing information about what the IC does in a pursuit of its national security mission, while at the same time protecting vital intelligence sources, methods, and activities. As you will remember, last week we discussed issues surrounding Admiral Rogers' recommendation for relief from duty by Secretary of Defense Ash Carter and ODNI, Director of National Intelligence, James Clapper. And we see here that James Clapper was the person that was in charge of the Intelligence Transparency Council. So what does this mean to us? Well, let's look at the Transparency Report, NSA Director of Civil Liberties and Privacy Office Report, NSA's implementation of Foreign Intelligence Surveillance Act, Section 702, April 16th, 2014. The seal of the National Security Agency, Civil Liberties and Privacy Office Report, NSA's implementation of Foreign Intelligence Surveillance Act, Section 702, April 16th, 2014. 2014, folks, 2 years prior to the Transparency Director being put in place. Introduction. This report was prepared by the National Security Agency, Civil Liberties and Privacy Office as part of its responsibilities to enhance communications and transparency with the public and stakeholders. Its director is the primary advisor as the director of NSA when it comes to matters of civil liberties and privacy. Created in January 2014, the office is also charged with ensuring that civil liberties and privacy protection are integrated into NSA activities. The intent of this paper is to help build a common understanding that can serve as a foundation for future discussions about the existing civil liberties and privacy protections. The mission of NSA is to make the nation safer by providing policymakers and military commanders with timely foreign intelligence and by protecting national security information networks. NSA collects foreign intelligence based on requirements from the President, his national security team, and their staffs through National Intelligence Priorities Framework. NSA fulfills these national foreign intelligence requirements through the collection, processing, and analysis of communications or other data passed or accessible by radio, wire, or other electronic means. NSA's authority to conduct signals intelligence collection for foreign intelligence counterintelligence purposes is provided primarily by Section 1.7.1 of Executive Order 12333 as amended. The execution of NSA's signals intelligence mission must be conducted in conformity with the Fourth Amendment. This includes NSA's acquisition of the communications to which a U.S. person is a part under circumstances in which the U.S. person has a reasonable expectation of privacy. The Foreign Intelligence Surveillance Act of 1978, FISA, further regulates certain types of foreign intelligence collections, including that which occurs when compelled assistance for U.S. communication providers. This report describes one way in which NSA meets these responsibilities while using Section 702 of FISA, as amended by the FISA Amendments Act of 2008. Although multiple federal agencies participate in Section 702 collection, this paper describes the process by which NSA obtains, uses, shares, and retains communications of foreign intelligence value pursuant to Section 702. It also describes existing privacy and civil liberties protections built into the process. The NSA Civil Liberties and Privacy Office, CLPO, used the Fair Information Practice Principles, FIP, as an initial tool to describe the existing civil liberties and privacy protections in place for collection done under Section 702 authority. Section 702 of FISA. Section 702 of FISA was widely and publicly debated in Congress both during the initial passage in 2008 and the subsequent reauthorization in 2012. It provides a statutory basis for NSA with the compelled assistance of electronic communications service providers to target non-U.S. persons reasonably believed to be located outside the U.S. in order to acquire foreign intelligence information. Given that Section 702 only allows for the targeting of non-U.S. persons outside the U.S., it differs from most other sections of FISA. It does not require an individual determination by the U.S. Foreign Intelligence Surveillance Court, FISC, that there is probable cause to believe the target is a foreign power and agents of foreign power. Instead, the FISC reviews annual topical certifications executed by the Attorney General and the Director of National Intelligence to determine if these certifications meet the statutory requirements. The FISC also determines whether the statutory requirements, targeting, and minimization procedures used in connection with the certifications are consistent with the statute and the Fourth Amendment. The targeting procedures are designed to ensure that Section 702 only used to target non-U.S. persons reasonably believed to be located outside the United States. Do you see the rub, folks? First of all, here's two members that have control over this circumstance by putting out annual topical certifications to allow the collection of this data without individual approval, done by the Attorney General, in this instance, Loretta Lynch, and at that time, Director of National Intelligence, James Clapper, a 3-star general. So this is very important information that now it seems to be salient that James Clapper went to President Obama and tried to have Admiral Rogers, Director of NSA, subsequently removed for poor performance after some whistleblowing and IC activity happened at the NSA based upon these requirements. The minimization procedures are designed to minimize the impact on privacy on U.S. persons by minimizing the acquisition, retention, and dissemination of non-publicly available U.S. person information that was lawfully but incidentally acquired under Section 702 by the targeting of non-U.S. persons reasonably believed to be located outside the U.S. Under these certifications, the AG and DNI issue directives to electronic communication service providers meaning telephone, cell data agencies, that require these service providers to immediately provide the government with all information or assistance necessary to accomplish the acquisition of foreign intelligence information in a manner that will protect the secrecy of the acquisition. The government's acquisition of communications under its Section 702 authority thus takes place pursuant to judicial review with the knowledge of the service providers. NSA cannot intentionally use Section 702 authority to target any U.S. citizen, any other U.S. person, or anyone known at the time of acquisition to be located within the United States. The statute also prohibits the use of Section 702 to intentionally acquire any communication as to which sender and all intended recipients are known at the time of acquisition to be located inside the United States. You see, it's against the law, folks, what just to even collect the information. NSA cannot intentionally, I'll read that again, NSA cannot intentionally use Section 702 authority to target any U.S. citizen, any other U.S. person, or anyone known at the time of acquisition to be located within the United States. The statute also prohibits the use of Section 702 to intentionally acquire any communications as to which, scrolling down, sender, all intended recipients are known at the time of acquisition to be located inside the U.S. Similarly, the statute prohibits the use of Section 702 to conduct reverse targeting, i.e. NSA may not intentionally target a person reasonably believed to be located outside of the U.S. if the person of such acquisition is to target a person reasonably believed to be located inside the U.S. So they can't purposely target someone outside the U.S. to get at somebody inside the U.S., which appears there's a second violation. All acquisitions conducted pursuant to Section 702 must be conducted in a manner consistent with the Fourth Amendment. NSA's FISC-approved targeting procedures permit NSA to target a non-U.S. person reasonably believed to be located outside the U.S. if the intended target possesses, is expected to receive, or is likely to communicate foreign intelligence information concerning one of the certifications executed by AG and DNI. Although the purpose of Section 702 is to authorize targeting of non-U.S. persons outside the U.S., the statute's requirement for minimization procedures recognizes that such targeted individuals or entities may communicate about U.S. persons or with U.S. persons. For this reason, NSA must also follow FISC-approved minimization procedures that govern the handling of such communications. NSA must report to the Office of Director of National Intelligence and to the Department of Justice any and all instances where it has failed to comply with the targeting or minimization procedures. There you see it, folks. They're required by law to notify James Clapper's office and the DOJ, the Attorney General, in the event of a violation or a failure to comply with the targeting or minimization procedures, which is what occurred. In addition, ODNI and DOJ had access to documentation concerning each of NSA's Section 702 targeting decisions and conduct regularly reviews in order to provide independent oversight of NSA's use of the authority. The FISC rules of procedure require the government to notify the court of all incidents of noncompliance with applicable law or with an authorization granted by the court. So there you see it, folks. The court is now complicit because they were also notified. They are required to notify the court. The government reports Section 702 compliance incidents to the court via individual notices and quarterly reports. In addition, the government reports all Section 702 compliance incidents to Congress, the Attorney General's semi-annual report. So they've notified Congress of this. And the Attorney General's semi-annual report includes that information. Depending on the type of severity of compliance incident, NSA may also promptly notify the Congressional Intelligence Committee, as well as the President's Intelligence Oversight Board on an individual compliance matter. There's two more parties that would have been notified: Congressional Intelligence Committee and the Presidential Intelligence Oversight Board of an individual compliance matter. Existing privacy and civil liberties section. So therefore, if the president says he didn't know anything about it, i.e. ex-former President Obama, he did because he was notified. The existing privacy and civil liberties protections. Each of three branches of the federal government oversees NSA use of Section 702 authorities. NSA provides transparency to its oversight bodies: Congress, DOJ, ODNI, DOD, the President's Intelligence Oversight Board, and the FISC, through regular briefings, court filings, incident reporting. In addition, DOJ and ODNI conduct periodic reviews of NSA's use of authority reports on these reviews. More recently, at the direction of the President, the government has provided additional transparency to the public regarding the program by declassifying FISC opinions and related documents. Although FISA surveillance is normally kept secret from the targets of surveillance, there are exceptions. For example, if the government intends to use the results of FISA surveillance to include Section 02 surveillance in a trial or other proceeding against a person whose communications were collected, the government must notify the person so the person can challenge whether the communications were acquired lawfully. So therefore, who have they notified? Are they planning on bringing someone up on charges? Therefore, they must have notified them of the surveillance prior to, so that they can determine if they were acquired lawfully. These protections implement the General Fair Information Practice Principle, FIP, of transparency. Before an analyst gains access to any NSA signals intelligence data, the analyst must complete specialized training on the legal and policy guidelines that govern handling and use of the data. Additional training is required for access to Section 702 data. These annual mandatory training requirements include scenario-based training, required reading, and a file competency test. The analyst must pass this test before being granted access. Furthermore, if a compliance incident involves a mistake or misunderstanding of relevant policies, the analyst is retrained in order to continue to have access to the data acquired pursuant to Section 702. Identifying and tasking a selector. Well, folks, this goes through the policies. These are very clear policies, and these folks have gone through training where they understand specifically what they are allowed to capture, what they are not allowed to capture, and if there is a mistake, they realize that it means retraining for them if they make a mistake, that they're going to have to sign off on it. So I ask you, there wasn't any mistake on the part of an NSA analyst. Any of this was done at behest or order from above. And what you will find is that this Section 702 and this FISA surveillance has not been used as it was originally intended. It has become an intelligence gathering device for inappropriate gathering of material. Because it was intended for things like protecting the rights of African Americans under, the Constitution, and 1/10 of 1% of those FISA warrants have applied to that specificity. So, folks, I'm going to stop sharing this document, and we will move on, because this is very important stuff. But we've just scratched the surface here, and you know much more of it that is to follow in the Q drops. So, what have we seen? We've seen that the NSA is apparently a branch of governmental spying, security analysis, that also does work in cooperation with the military, cryptologic assets. So they gather intelligence. It is an intelligence gathering operation. And it coordinates well within the Office of the Director of National Intelligence and the Attorney General and the Department of Justice, and additionally with Congress and the President, with regard to executive and legislative oversight. And what we've seen is that there, just by reading the standardization transparency documents, we've already seen at least 3 violations with regard to what was done with President Trump, 3 violations of those legal requirements, even to just do the intelligence gathering that it did with President Trump. So there are people who are liable, and those people right off the bat are Loretta Lynch and James Clapper immediately, because they are the public administrators responsible for that area of specialty. So what we're going to do is we're going to move on. Why is this important? This is important because what I'm going to demonstrate, and what I've attempted to demonstrate through my last several shows, is that this has all been about legal manipulation. And this week's powerful word is transparency. And if going forward, what is required is transparency, we need to understand what transparency will deliver with regard to these issues. For example, let's just take the NSA issue, for example, with regard to the semi-annual notifications to Congress regarding any violations of the FISA agreement. If there are violations, they're regard to Americans' rights, to U.S. personnel's rights in this country that have been violated. So transparency would say that people, Americans, real people from this sovereign republic, should be reviewing that semi-annual report so that we know and we can report to our fellow Americans any violations against our privacy. And those are the type of things we ought to be investigating, how we get in the middle of these organizations so that we have critical transparency of the violations, because we're not asking for the intelligence, we're not asking for what's being done, we're asking for the legal violations of standardized procedures to protect our rights. And that's the type of thing that I am interested in doing as an American. I want to know how to protect your and my rights. And so on that vein, what I want to do is discuss the most troubling issue to me, and one that I've frankly been covering for the last several weeks, is the issue surrounding the apparent information that is consistent with the books of Daniel and the book of Revelation, in that we're beginning to see an empire, the Empire of Rome, from the dream of Nebuchadnezzar, the 2 legs of the Roman Empire, the Iron Empire of Rome, has continued to exist throughout history, though we were told historically that it had ended roughly 476 AD. And why is that pertinent? From a big biblical standpoint, it's extremely pertinent because it leads to the following. It confirms what the dream of Nebuchadnezzar, a pagan, Nebuchadnezzar, King of Babylon, had a dream, and it confirms that that dream was correct, historically correct, and predictively correct. Additionally, it points towards the Lord, because the Lord always tells us things prior to them happening so that we might know that he's there and that he is God. And additionally, it also purports that we are entering a time, biblically, that it is important, as it said in the book of Daniel, that these things will be sealed up until the end times when they might be relieved. So Daniel was told to seal up the scroll and seal these things up. Well, they're coming out, folks. They're coming out, and I'm humbled to think that I may be one of those platforms where the Lord is sharing this information with us, but it's becoming extremely relevant, because let me tell you about the following. Everyone's heard about the four horsemen of the apocalypse, but few who don't study the Bible understand that the four horsemen of the apocalypse are bringers of certain issues and dominance and delivers of circumstances on the earth that set up God's plan for the time of great tribulation. And the first rider of the apocalypse is a rider upon a white horse. And the rider has a bow, but the rider has no arrows in his quiver. And the Revelation tells us roughly, and I never want to get incorrect with Revelation, so I will turn to Revelation and do a teaching on this on my own channel, on disambiguation. Basically, what we're dealing with is a horseman that conquers the world without any arrows in his quiver, meaning he conquers the world through other than through hostilities, other than through using military powers. But there is a bow involved, so there are arrows involved, and I would what we're going to see is that this is the one world government being brought about. This is the world being conquered without any arrows. And what I've found is really alarming, really transparent, really convincing information to prove that that's the circumstance in which we live, and why. What I've additionally found out is why they had to take over England, and why they used the character that they used. And so that's what I want to go into next. So let's venture into some of these articles that I've got pulled up, and I want to begin with a certain premise that I know that it has something to do with this legal person thing. And that's what I first began studying when I started out, because I want to understand the legal person issue. I want to understand how and why that could be used to manipulate our Constitution, to subjugate or to bypass our Constitution. And what I believe I found is why they did that, folks. So give me a second here. I'm going to share this document with you. And there are many other documents that I can share with you, but I'm going to do a very quick teaching today, very, very quick share with you, because this one is huge, and it really needs to be given the time that it deserves. And frankly, this week, because of the guests I have coming in, coincidentally, Ralph Epperson will be in on Saturday the 16th, and Gary Wayne will be in the same afternoon. And boy, this poses to be a wonderful day, folks, for question and answer, and filling our brain housing groups with a bunch of information, and arming us and preparing us to go out and be ready for whatever the world gives us. So bear with me a second. I'm going to bring this article up. Okay, this article is a UMass article, University of Massachusetts And I'm going to scroll over some of the writings they have at the top. But what I wanted to do is get at the heart of the matter here. So bear with me a second. I'm going to drag some stuff around here and get this clear. The purpose in this essay is to explore the doctrine of corporate personality, to deconstruct the metaphor of legal being, to reveal it as an intersection of competing discourses, as a point of fracture in which different systems of signs are transposed, translated, and articulated. The concept that a corporation is a person is the legal core of corporate power. When the U.S. Supreme Court overturned New Hampshire's attempt to turn Dartmouth College into a public institution, Dartmouth College versus Woodward, 17 U.S. Reports 518, 1819. And this is really important information, folks. You need to understand how a college can overcome a state, the rights of a state. And that's what I've located, and that's what they did. The court subordinated a state legislature to an artificial being, the college corporation. The court held that a charter from the British Crown creating the college was contract protected from the legislative impairment by federal constitution. Excuse me? A contract created by the British Crown was protection against our federal constitution? Say what? The court said the college corporation provided for the maintenance of property rights by a, quote, a perpetual succession of individuals capable of acting like one immortal being. Do you hear how evil this is, folks? What they've done is they've turned the corporation of all the people that have worked at the corporation, being the university, and the people that have gone there, into an immortal being, because all of the people constitute the one life, not the individuals. The court's comment that its immortality no more confers on its political power than immortality would confer such power on a natural person denied human experience as it postulated an artificial world of legal being. So it's created a legal artificial world of being, and that artificial world of being has subjugated the real world of you and I. And that's just tough to grasp, folks, but you got to stay on board here. You have to follow this. It's really important that we do. Two approaches to legal personality. By the late 19th century, corporations had become major institutions. Their legal conceptualization as artificial hardly fitted the reality of their power. Large manufacturing corporations and railroads rivaled governments. Corporate legal battles were not limited to preservation of their characters or charters, but extended to ever wider attempts to deploy property and exercise coercive force. Assertions of corporate power independent of the state and challenging the terms of corporate legal existence positively traumatized legal thinking and created a crisis of legal imagination at the turn of the century. Mark 1987, 1445. Frederick William Maitland pointed out in 1900 that in the second half of the 19th century, corporate groups of the most various sorts had been multiplying all the world over at a rate that far outstrips the increase of natural persons. So they said that more companies were being born than humans. And a large share of all our newest law is law concerning corporations. He went on to say that something not unworthy of philosophic discussion would seem to lie in this quarter, either some deep-set truth which is always bearing fruit, or else a surprisingly stable product of mankind's propensity to feign, to lie, to fake, to fool. So what he's saying is this is either a truth that we haven't grasped that's at the center of our being, or it's men's ability to really lie badly. And we're going to find that that's the truth. Maitland's comments appeared in the introduction of his translation of Otto Gierke's History of Political Theory in the Middle Ages. Gierke's presentation of Germanic concepts of organic group life offered the possibility of a deep-set truth, that corporate entities exist prior to and independent of the state. Hold up. They just said right there that Gierke said that organic law offered this deep set truth that corporations, since they were formed before the states, supersede the state. Whoa. So you mean any company that was formed before the United States therefore supersedes the state's rights because its corporation is the real immortal person that we collectively ensue. This is going to bend your brain, folks. You really got to watch how evil they are, because this one's going to twist you. Far from being artificial creatures of the state, corporations might be seen as real legal persons. How can a corporation be a real legal person? Well, I'm about to tell you. Deriving their powers and legitimacy from their own internal processes as human fellowships or associations. Do you believe that stuff, folks? They are saying, and I'm going to stop the share for the second because I want to share with you here. They're saying that because corporations are fellowships of humans and we are associations, that we belong to groups, that now the corporation, the association, the club is the human being. They are the legal entity. We are not the humans. They are the companies. They're the companies. And you're going to find that the reason they did this is because it is the way to take over the world. It is the method by which they can take over the world. And this, you're going to find out that this is what Rome always did. And we didn't know it. This is what Roman law has always had. That the idea of the corporation always outweighed the idea of the state. And that at the top of Roman law, there's always the Kaiser, the Caesar. So everything falls under him. And states are subservient to the corporations because the corporations precede them. Let's be honest. These corporations, let's say the Dutch East India Corporation, they went and conquered Indonesia, right? East India is Indonesia, folks. The East Indies, that's Indonesia. So they conquered Indonesia. So Indonesia, because it was a state that was formed after the corporation hierarchically, legally, supersedes the rights of the state. Whoa. Bend my brain, why don't you? So let's go back to this article for a moment and let's dig a little deeper here. Okay. Back to Maitland's comments appeared in the introduction of the translation of Ardo Gierke's History of the Political Theory in the Middle Ages. Gierke's presentation of Germanic concepts of organic group life offered the possibility of a deep-set truth that corporate entities exist prior to and independent of the state. Far from being artificial creatures of the state, corporations might be seen as real legal persons, deriving their powers and legitimacy from their own internal processes as human fellowships or associations. Maitland suggested that this Germanic concept of real corporate personality might legitimize the economic and political reality that was emerging in American England. It would allow law to take the side of the corporation against the state, not simply where the state had already provided for specific protections, but in generalized way on behalf of a self-directed corporate autonomy, a form of group sovereignty as the source of their own legitimacy. Real legal persons would be in a position to negotiate with the state. Fictional legal persons, on the other hand, were dependent on the state authority for their existence and legitimacy. They were subsumed in state sovereignty. Their existence was entirely feigned by the law. So, they created fictional legal persons. By the way, that's what they did to each of us. They created fictional legal persons, and that person, that legal person, was subsumed in state sovereignty. Therefore, we're legitimized by our relationship with the state, but we are fictional. We're not real. We're fiction. The fiction concept of corporate personality claims a Roman pedigree. Roman pedigree. Gierke refers to a tradition snaking back through the Middle Ages to Pope Innocent the 14th, pontificate 1243 to 54, who relied on phrases in Justinian's Digest to declare that church bodies could own property as persons. They could own slaves, folks. The difference between the Roman and German traditions, as Maitland pointed out, is between an abstract institution existing only in contemplation of law and a living group existing in a sovereign expression of its members. Maitland's translation, brought Gierke's vision of the organic viewpoint of corporate associations to English-speaking jurists who were looking for an alternative to the fiction conception to rationalize the overwhelming economic and political power being marshaled by corporations. The organic view, though it did not triumph in its own right in American law, fueled debate about whether corporations depend on the state or are directly legitimized by human right of free association. This stuff doesn't fail to impress. They are so crafty and so clever and so manipulative. And guess what? What this is going to demonstrate in the next document I'm going to go through, I apologize, it's a lot of reading material. But what I'm going to go through is going to show you that the church was the law. Rome was the basis of law. The lawyers were the proponents of this plan. The corporations were the method by which they conquer. And the universities are the corporations. And, for example, why did Freemasonry launch itself on May 1st, 1776? Because it was an organization prior to our independence. Therefore, according to this legal representation, it supersedes our rights. Does that bend your brain in half or what? Let's continue. The jurisprudential debate came to its crisis as corporate power intensified throughout the last half of the 19th century, and political opposition emerged from populist legislatures. Populists enacted a variety of legal obstacles to corporate businesses. States' rights were asserted against foreign corporations, license fees set for doing corporate business within a state, bond requirements established, and other measures taken that from a national corporate point of view threatened economic balkanization. Graham, 1955, page 166. Corporations challenged populist restrictions with a barrage of litigation claiming equal protection and due process rights under the 14th Amendment. 14th Amendment, folks, back to NSA. Fourth Amendment there. Corporate lawyers aimed at stretching the federal constitution to create a national market free from state regulation. U.S. Supreme Court Justice Hugo Black once pointed out that of the cases in this court in which the 14th Amendment was applied during the first 50 years after, forgive me, folks, I made a false attribution previously. I confused the 4th and 14th Amendments. Here's the attribution here. This is the correction. U.S. Supreme Court Justice Hugo Black once pointed out that of the cases in this court in which the 14th Amendment was applied during the first 50 years after its adoption, less than 0.5% invoked it in the protection of the black race, and more than 50% asked that its benefits be extended to corporations. 50%, folks. This was used to benefit the corporations, not to benefit those people that it was meant to protect, the 14th Amendment. The lawyers manipulated the 14th Amendment. Connecticut General Company versus Johnson, 303 U.S. Reports at 90 in 1938. The railroad provisions of California's Constitution of 1879 were a high watermark of anti-corporate populist law. These included an elected railroad commission and the State Board of Tax Equalization and a provision prohibiting deduction of railroad mortgage costs for property tax purposes. This provision aimed at distinguishing between mortgages for personal property, e.g. homes, and mortgages for business capitalization. Do you see what they're going at, folks? They're now looking at property. Targeting of railroad mortgages was explained by reference to the fact that railroads, unlike other property, were mortgaged far more than cost, yet still paid handsome dividends. Graham, 1955, 180, the activities of the Board of Tax Equalization applying the mortgage provision led to a confrontation in federal court with the Southern Pacific Railroad. Well, we know that the Illuminati families owned the railroads, so here you go. They brought their lawyers. The ensuing litigation, Santa Clara County versus Southern Pacific Railroad, 118 U.S. Reports 394, 1886, resulted in a clear victory for corporate partisans. The U.S. Supreme Court declared the railroad to be a person. Do you hear that, folks? They declared the railroad to be a person within the meaning of the 14th Amendment, a much broader protection than provided to Dartmouth College. So now they've got a higher protection than Dartmouth College was, even though Dartmouth College was formed by the king. 14th Amendment recognition of corporate personality provided corporations with a generalized freedom to use property in opposition to state government restrictions. So they could use their property because they were human beings. They were now persons, so they could use their property to violate states' rights because they had property. So therefore, they superseded the rights of the state. The court does not wish to hear argument on the question whether the provision of the 14th Amendment to the Constitution, which forbids a state to deny any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. Isn't that crazy? That's crazy. They gave corporations the right to be these fictitious persons, so they supersede the court's rights. I mean, the state's rights. However, satisfying to corporate lawyers, the concept was troubling for jurisprudence. As Maitland suggested, the growing power and increasing recognition of corporate persons demanded attention to the philosophical foundation of legal personality itself. Was corporate personality an expression of some deep-set truth, or simply a product of mankind's, read the laws, propensity to feign? Was the corporate person real or artificial? On this question depended the legitimacy of the state as well as the corporate entities. So now you can see, now we've got a problem. If they tell the truth, it means the corporation loses their rights because they're now determined to be a fictitious item. Because what is a corporation? It's nothing more than a vehicle by which board of directors or the directors of the corporation perform some legal matters, contracts and such. The state, on the other hand, what is the state? The state is actual property. The state has an actual property, but that's what the corporation is arguing, that since they have property and since they were established prior to the state, they supersede the state's rights. Crazy stuff. The terminology of jurisprudence was betraying its difficulty in coming to terms with human existence as well as human association. They had now run into a philosophical argument for which the law started to struggle. They couldn't answer this one. You're talking about philosophical issues, existential, who am I, what am I? And that's why, folks, I need you to pay attention to Bill Clinton as the key. His statement, that depends on what your meaning of the word is, reflected his specific training by the Jesuit University of Georgetown into these concepts. Because he could question whatever their intention was, whether it was a fictitious person or a real person. And instead of doing that, he didn't want to let the cat out of the bag. They told him to just tell the truth. And so he told a partial truth. Even if it were true, as it not, that natural person, a wholly unambiguous term, a natural person, a person in the legal sense, is to confer upon it a new, additive, and distinctive meaning, the root difficulty in present controversies about the natural and associated bodies may be that while we oppose one or the other or try to find some combining union of the two, what we really need to do is overhaul the doctrine of personality which underlies both of them. Dewey, 1926, 657 and 58. Before mid-century, jurisprudential trauma was resolving into a consensus that corporations and natural persons were, insofar as law was concerned, basically the same. The crisis of legal imagination in grappling with the corporate personality was settling into an agreement no longer to ask difficult questions about the essence of personality. In a place of definition of legal personality, jurisprudence moved toward an approach that is dominant as the 20th century comes to an end, the analysis of interests with an eye to the costs and benefits. Dewey's plea resonated in jurisprudential circles and presaged the future. As far as the historical survey implies a plea for anything, it is a plea for disengaging specific issues and disputes which arise from entanglement with any concept of personality which is other than R.E. statement that such and such rights and duties, benefits and burdens accrue and are to be maintained and distributed in such and such ways and in such situations. 1926-69, emphasis on the original. You can imagine the government's struggling with this. The states are struggling with it. The states have realized they have less rights than the corporation. The Supreme Court's refusal to hear argument in Santa Clara about its extension of the 14th Amendment jurisprudence was a prime example of Dewey's assessment of the law's lack of need for theory. There is no general agreement regarding the nature in se of the jural subject. Courts and legislators do not do their work without such agreement, sometimes without any conception or theory at all regarding its nature. It can be shown that recourse to some theory has more than once operated to hinder rather than facilitate the adjudication of a special question of right or obligation. Dewey, 1926, 660. So what we're starting to see, folks, is that we're in a real quandary here because now people have figured out that the corporation has the same rights or more rights than a human being. The doctrine of full-fledged corporate personality and legal discourse coincided with the historical separation of finance capital from industrial management. Two types of property were presented by an emerging fragmentation of corporate political economy. One, the physical assets of a corporation operated by its managers. The other, the claim of investors to a share in profits generated by such operation. So now you got a problem. You've got this corporate entity which doesn't exist, though it has been given person status because it is a group of individuals which, because they exist, they transfer their existence to the corporation. But now you've got shareholders. You got shareholders who own part of the corporation. How are they viewed? The position of investors, so different from the individual proprietors envisioned in classical theories of market society, was exposed by Pablo's distinction between property owned for the use and property owned for profit. The tax provisions of 1879 California Constitution, by changing the mode of assessment in order to get at the going value of the railroads, as contrasted with the cash value of their assets, levied on the profit-generating capacity of the railroads. This change threatened not only the railroads, but the whole system of finance capital, which underwrote and depended on the profitability of corporate concentration. Rome was challenged. They were challenged. They were challenged by shareholders, which, you know, is maybe not an entirely American problem, but it really came to a head here. Railroad lawyers seem to have been particularly prescient in this matter, meaning that they thought ahead about the matter. Property, heretofore tangible property, had to be equated to earning power or exchange value, or as one of the pioneer Southern Pacific Railroad briefs put it, in a truly inspired and prophetic typographical error, the phrase in the 14th Amendment had to be read as deprived of profit, not property, without due process of the law. Graham, 1955, 164. So what we're seeing, folks, is lawyers and more lawyers and some more lawyers and other lawyers get together and determine that we really have no rights, that those rights all are owned by the corporation and thus go back to Rome. American progressives and legal realists approach the displacement of individuals by corporate persons as a problem for jurisprudence generally. Maitland had made available Germanic notions of group will and suggested a legal framework that would admit groups to the status of real persons, but the fracture of management from ownership left the corporate person with a split personality not amenable by the Germanic concept. United States jurists preferred to rely on the Roman derived fictional person. You see the answer, right? This is their answer. This is why they had to come up with the Organic Act. Why is it called organic? Because organically in law, we are organic humans, and what they did was to supersede that, was to come up with the fictional person doctrine that is common in Rome, and solve the problem of what to do with natural persons by dismissing them from law, except in insofar as they might fit within this fiction. There were to be no real legal persons except the state itself. So the state now is the only legal person. The corporation is the only legal person, and we don't exist. We are merely assets to be looked at as part of the bundle of either a corporation or a state. In Dewey's words, for the purpose of law, the conception of person is a legal conception, but put roughly, person signifies what the law makes it signify. The only reason there was any confusion about this was the extraneous influences had been introduced into legal practice, including a mass of non-legal considerations, popular, historical, political, moral, philosophical, metaphysical, and in connection with the latter, theological. So now you see everybody's included, folks. Popular, history, politics, morals, philosophy, metaphysics, and theology. Everybody's involved in this. They're all involved. Clearly, the pragmatists of the day were of a mind to separate law from the rest of life, excluding all discourses not pertaining to the strictly legal sphere. The fact that this legal sphere itself carried metaphysical and theological pedigrees was overlooked. You see that, folks? It came from metaphysics and from religion, from Rome, from the Vatican, and it was overlooked. After World War II, the place of corporation law had ceased to be controversial, and both theoreticians and practitioners concerned themselves instead with organizational theory and economic analysis of corporate behavior. The corporation as a legal institution ceased to be of interest. As a result, the modern lawyer knows only that a corporation is considered a legal person, but finds the terminology devoid of content. So they don't care anymore. It's just they just let's just forget it. It ain't important. It don't matter, Eddie. Let's just overlook it. These are not the droids you're looking for. On the other side, economic analysis of the law provides only an apology for legal personality on one side. And on the other side, Marx's base superstructure image fails to explain the power of legal discourse generally. So now they got Marx involved. So now you're talking 1850s. They're starting to discuss communist views of how this law is perceived. And let's be honest, they're mentioning Germanic law. Why are they mentioning Germanic law? Well, that is where we're going next. So let's look at this for a moment. I want to bring up that's not pertinent. Okay. Yeah, I guess if your brother was Lord Balfour, you'd probably call yourself FM Maitland too. You wouldn't want them knowing Lord Balfour was your brother, huh? Okay. Okay, bear with me a second. I gotta find the document I'm looking for. Okay, here we go. Let me open this up down here. Okay, this is the introduction that was referred to earlier by F.W. Maitland. And his introduction to Gurkha's Middle Age Political Theories book. Let's let it propagate here for a moment. Okay. London, C.J. Clay and Sons, Cambridge University Press Warehouse, Stevens and Sons Limited, Chancery Lane, Otto Gurkha, 1900. Okay. Frederick William Maitland did the introduction, Downing Professor of the Laws of England in the University of Cambridge. Okay, this one's going to blow your socks off, so you might want to take them off anyway. So I'm going to pause while you remove your shoes and yank those socks off because I don't want to blow them off. But I'm going to read this entire introduction, and it's going to drive you mad because you're going to hear way too much Caleb, too much Caleb, too much Caleb. It's too much Caleb. And we know what that is, and you know what the cure to too much Caleb is. More Caleb. There you go. So let me come at you with this, and bear with me because it's long, but it really is full of content that we need to understand. Had what is here translated, namely a brief account of the political theories of Middle Ages, appeared as a whole book, it would hardly have stood in need of that distorting medium of an English translation. Englishmen who were approaching the study of medieval politics, either from the practical or from the theoretical side, would have known that there was a book which they would do well to master, and many who were not professed students or whose interests lay altogether in modern times would have heard of it and have found it profitable. The elaborate notes which have shown that its writer had read widely and deeply, they would also have guided explorers into a region where signposts are too few. As to the text, the last charge which could be made against it would be that of insufficient courage and generalization, unless indeed it were that of aimless medievalism. The outlines are large, the strokes are firm. Medieval appears to have been an introduction to modern thought. The ideas that are to possess and divide mankind from the 16th until the 19th century: sovereignty, the sovereign ruler, the sovereign people, the representation of the people, the social contract, the natural rights of man, the divine rights of kings, the positive law that stands below the state, the natural law that stands above the state. These are the ideas whose early history is to be detected, and they are set before us as thoughts which, under the influence of classical antiquity, necessarily shape themselves in the course of medieval debate. And if the thoughts are interesting, so too are the thinkers. In Dr. Gurkha's list of medieval publicists, beside the divine and schoolmen, stand great popes, great lawyers, great reformers, men who were of clothing concrete projects in abstract vesture, men who fashioned the facts as well as the theories of their time. Okay, why is this pertinent, folks? Because in that last piece, it was mentioned that the basis or the origin for this, which I think is frankly much, much earlier, was the Pope Innocent the 14th, or excuse me, the 14th, who Innocent the Fourth, excuse me, in 1248, who was following just Emperor Justinian's paperwork. And so when you want to discuss where they found this information out and how they subjugated our rights, how they submitted that the state's rights were subordinate to the corporation's rights, came from their education of these documents. And so it's important for us to understand that they knew this, and lawyers knew this well in advance of writing our Declaration of Independence. Lawyers knew this, and you knew that many of the lawyers were the ones that signed it. 4 lawyers signed the Treaty of Paris. many lawyers signed our Constitution. They knew this information. And since they knew this information, they knew that our Constitution could be subjected. They knew that it could be manipulated. And they knew exactly how. Moreover, Englishmen should be especially grateful to a guide which is perhaps his strongest, just where they must needs to be weak. That is, among the books of the legists and the canonists, so lawyers and theologians. An educated Englishman may read and enjoy what Dante or Marsiglio has written. An English scholar may face Aquinas or Occam, or even the repellent Wycliffe. But Baldus and Bartolus, Innocentius and Johannes Andre, them he has never taught to tackle, and they are not to be tackled by the untaught. And yet they are important people, for political philosophy in its youth is apt to look like a sublimated jurisprudence, and even when it has grown in vigor and stature, is often compelled or content to work with tools, a special contract, for example, which has been sharpened, if not forged, in the legal smithy. If in that smithy Dr. Gierke is at home, with perfect modesty he could say to a learned German public, it is not probable that for some time to come anyone will tread exactly the same road that I have trodden in the long years of fatiguing toil. Now, we need to understand, I've stated before and I'm going to state again, and the reason why I'm showing this is because the Roman Empire supposedly had ended in the West in 476, but it continued. It continued in name only, and it continued with regard to status, title, and participation with Rome, because to Rome they couldn't do without the empire, and the empire could not do without the Vatican, without the Roman Church. They were hand in hand throughout history. And what we see is that the Roman Empire was never able to conquer the Northern Germans, and I've shown you the map there before. They were never able to conquer Scotland. They were never able to conquer Ireland or Scandinavia, because these were tribal people. And the tribal people had a different sense of law. And coincidentally, the American Indians, tribal people. And you're going to find through further investigation of this that Indian law supersedes the state's law. Why is that? This is why. So if you want to understand that basis, you have to read this document. But then, what is here translated is only a small, a 20th part of the large, as yet unfinished book, bearing a title which can hardly attract many readers in this country, and for which an English equivalent cannot easily be found, namely Das Deutsche Genossenschaftsrecht. Of that work, the third volume contains a section entitled Die Publistischen Lehren des Mittelalters, and that is the section which here is done in English. So we're only doing a section of his book, and that's really an important part here. That is the section that here is done in English. Now, though this section can be detached and still bear a high value, and though the author's permission for its detachment has been graciously given, still it would be untrue to say that this amputating process does no harm. The organism which is a whole with a life of its own, but is also a member of a larger and higher organism whose life it shares, this, so Dr. Gierke will teach us, is an idea which we must keep before our minds when we are studying the political thought of the Middle Ages. And it is an idea which we may apply to this and to every good book. The section has a life of its own, but it also shares the life of the whole treatise. Nor only so, its membrum de membro is a section in a chapter entitled The Medieval Doctrine of State and Corporation, which stands in a volume entitled The Antique and Medieval Doctrine of State and Corporation and its Reception in Germany. And this again is part of Das Deutsche Genossenschaftsrecht. Indeed, our section is a member of the highly organized system. In that section are sentences and paragraphs which will not yield their full meaning except to those who know something of the residue of the book and something also of the controversial atmosphere in which a certain Genossenschaft theory has been unfolding itself. This being so, the intervention of the translator who has read the whole book, who has read many parts of it many times, who deeply admires it, may be of service. In a short introduction, even if his own steps are none too sure, he may be able to conduct some of the fellow countrymen towards a point of view which commands a wide prospect of history and human affairs. Now let's remember, this is an English professor at Oxford writing this introduction to this book. Okay? That's important. Staats- and Corporationslehre, the doctrine of state and corporation. Such a title may be to some a stumbling block set before the threshold. A theory of the state, so it might be said, may be very interesting to the philosophic few and fairly interesting to the intelligent many, but a doctrine of corporations, which probably speaks of fictitious personality and similar artifices, can only concern some juristic speculators, of whom there are none or next to none in this country. On second thoughts, however, we may be persuaded to see here no rock of offense, but rather a stepping stone which our thoughts should sometimes traverse. For when all is said, there seems to be a genus of which state and corporation are species. They seem to be permanently organized groups of men. They seem to be group units. We seem to attribute acts and intents, rights and wrongs to these groups, to these units. Let it be allowed that the state is a highly peculiar group unit. Still, it may be asked whether we observe ourselves and not in the slaves of the jurist theory and a little behind the age of Darwin, if between the state and all other groups we fix an immeasurable gulf and ask ourselves no questions about the origin of species. So here they are evoking their master Darwin, because that's what they're going to use. They're going to use evolutionism in species. They're going to use that as their basis for this determinant. Certain is that our medieval history will go astray, our history of Italy and Germany will go far astray unless we suffer communities to acquire and lose the character of states somewhat easily, somewhat insensibly, or rather unless we both know and feel that we must not thrust our modern state concept, as a German would call it, upon the reluctant material. So they're saying, look, we as British or folks from England, we as folks in the States, we cannot conceptualize our understanding of the state upon this information, because how the Romans conquered the rest of the world is that they conquered Germany by combining Germanic and canonical law. They couldn't conquer it by war, but they conquered it through the church. English in particular should sometimes give themselves this warning, and not only for the sake of the Middle Ages, fortunate in littleness and celerity, England could soon exhibit as a difference in kind what elsewhere was a difference in degree, namely, to use medieval terms, the difference between a community or a corporation. Now, in Latin, corporation is universitas. Go figure! Which does, and one which does not recognize a superior. So one doesn't recognize a superior and one does. There you see the dilemma. There you see why they had to conquer England, because England had common law. And Germany was not sending ships around the world to conquer the world, because Rome had given the money to England, Spain, the Dutch, and the Portuguese corporations to conquer the world. And the English revolted. Henry VIII kicked the Pope to the curb, right? And started the Church of England, Reformation. So they had to figure out how to resolve this. There was no likelihood that England with the Norman Duke had subdued and surveyed would be either Staatenbund or Bundesstaat, and the aspiration of Londoners to have no king but the mayor was fleeting. No king but the mayor. Does Lord Mayor ring a bell? The Londoners only wanted a mayor, they didn't want a king. Thus, if it diminished or expenditure of blood and treasure, an expenditure that impoverishes diminished also our expenditure of thought. An expenditure that enriches and facilitated, might this not be said, a certain thoughtlessness or poverty of the ideas. The state that Englishmen knew was a singularly unicellular state, and a critical time they were not too well equipped with tried and traditional thoughts which would meet the case of Ireland or some communities, commonwealth corporations in America, which seemed to have wills and hardly fictitious wills of their own, and which became states and United States. So in England, you didn't have the concept of states. You had them as Londoners wanting a mayor. They didn't want a king. In 1648, you got Cromwell coming over. Well, who funded Cromwell? Well, the Dutch. So the money pours in from the money changers because they want to return to England because they've been kicked out in 1207. They want a return to England legally. So in which they did through Cromwell. Well, why did Cromwell bring them with him? Because the Vatican, the Catholic Church, the Pope had funded this move through the corporations. They provided the funding so that this all could be moved to England, because Rome had to conquer England, and the only way they could conquer England was by establishing Germanic, Romanic law in their London outpost, the City of London. And that's what they did, folks. And so, reviewing this document further, what we find is we find exactly how they did it. Deeply convinced though our lawyers may be that individual men are only real and natural persons, they are compelled to find some phrase within places, state, and man upon one level. The greatest of artificial persons, politically speaking, is the state. So we may read in an excellent first book of jurisprudence, ascending from the legal plane, we are in middle region where a sociology emulous of the physical sciences discourses of organs and organisms and social tissue, and cannot sever by sharp lines the natural history of the state group from the natural history of other groups. Finally, we are among the summits of philosophy and observe how a doctrine which makes some way in England ascribes to the state, or more vaguely, the community, not only a real will, but even the real will, and it must occur to us to ask whether what is thus affirmed in the case of the state can be denied in the case of other organized groups. For example, that considerable group, the Roman Catholic Church. It seems possible to one who can only guess that even nowadays a Jesuit may think that the will of the company to which he belongs is no less real than the will of any state. And if the reality of this will be granted by the philosopher can be paused until even so-called one-man company has a real will, really distinct from the several wills of one man and his 6 humble associates. If we pursue this thought, not only will our philosophic Stoffslehre be merging itself in a wider doctrine, but we shall already be deep in the Genossenschaft theory. In any case, however, the law's old habit of coordinating men and bodies, politic, as 2 kinds of persons, seems to deserve the close attention of the modern philosopher. For though it be an old habit, it has become vastly more important in these last years than it ever was before. In the second half of the 19th century, corporate groups of the most various sorts have been multiplying all over the world at a rate that far outstrips the increase of natural persons, and a large share of our newest law is law concerning corporations. Something not unworthy of philosophic discussion would seem to lie in this quarter, either some deep-set truth which is always bearing fresh fruit, or else a surprisingly stable product of mankind's propensity to feign. Howbeit, this rare atmosphere we do not easily breathe, and therefore will for a while follow a lower road. So what we're seeing, folks, is we're seeing that lawyers knew this. This is not new. It came out of 1248 from Justinian and from Innocent IV, Pope Innocent IV, and that the lawyers understand this, and they also understand that this has to be understood to understand the current relationship between a state, a corporation, and Roman law. A large part in the volume that lies before the translator is played by the reception. When we speak of the Renaissance and the Reformation, we need not be at pains to name what was reformed or what was born anew, and even so, a German historian will speak of the reception when he means the reception of Roman law. So the Germans don't speak of the Reformation. They don't speak of, they speak of the reception of Roman law. They believe that that was the Reformation. Very often, Renaissance, Reformation, or Reception will be set before us as three intimately connected and almost equally important movements which sever modern from medieval history. Modern Germany has attained such a preeminence in the study of Roman law that we in England may be pardoned for forgetting that of Roman law, medieval Germany was innocent and ignorant, decidedly more innocent and more ignorant than was England of the 13th century. It is true that in Germany, the theoretic continuity of the empire was providing a base for the argument that the law of Justinian's books was or ought to be the law of the land. It is also true that the corpus juris was furnishing weapons useful to the emperor, who were at strife with the popes. But those weapons were fashioned and wielded chiefly by Italian hands, and the practical law of Germany was as German as it well could be. Also, and here lay the possibility of a catastrophe, it was not learned law, it was not taught law, it was far from being Juristenrecht. Englishmen are, meaning that they were tribal. They used the verbal tradition, just like the Jews, just like the Irish, the Scottish, and the Indians. They were tribal. So most of their law was not written law. It was verbal law. It was history told in the tribe. Englishmen are wont to fancy that the law of Germany must needs savor of the school, the lecture room, the professor, but in the truth it was just because German law savored of nothing of the kind, but rather of the open air oil tradition and thoroughly unacademic doomsman, that the law of Germany ceased to be German, and that the German law has had to be disinterred by modern professors, because the Romans knew this. They knew that there was no written tradition, so they knew if they overtook this, that they could institute whatever they wanted to put in its place as the written tradition. Of the geographical and historical causes of the difference we need not speak, but in England we see a very early concentration of justice, and then repaid growth of a legal profession. The yearbooks follow, and the Inns of Court, and the lectures on English law and scholastic exercises, and that call to the bar of the inn, which is in fact an academically earned degree. Also long, and what is the bar of the inn, folks? It's the church. Also long before Germany had universities, Roman law was being taught at Oxford and Cambridge, so that it would not come hither with the glamour of the Renaissance. A certain modest place had been assigned to it in the English scheme of life. Some knowledge of it was necessary to the students of lucrative law of the church, and few civilians were required for what we should call the diplomatic service of the realm. But already in the 14th century, Wycliffe, the schoolman, had urged that if law was to be taught in the English universities, it ought to be English law. In words which seem prophetic or modern Germanism, he protested that English was as just, as reasonable, as subtle as Roman jurisprudence. So you're starting to see the seeds of rebellion in the 14th century with the English becoming educated and determining that they had their own brand of law, that they wanted to supersede Roman jurisprudence. So you see why they had to be conquered. Thus, when the perilous time came when the new learning was in the air and the modern state was emerging in the shape of Tudor monarchy, English law was and had long been lawyers' law, learned law, taught law, juristenrecht. Disgracefully barbarous, so thought one enlightenment apostle of new learning, Reginald Pole, and his vice was brought to his royal cousin was for sweeping it away. In so many words, he desired that England should receive the civil law of the Romans, a law so civil that nature's self might have dictated it, and a law that was being received in all well-governed lands. We must not endeavor to tell the story of the danger that beset English law when the future Cardinal Archbishop was speaking thus. A glance towards Scotland would show us that the danger was serious enough and would have far more serious but for the continuous existence of the Inns of Court, and that the Indoctism genus Doctissimorium hominum, which was bred therein, then late in the 16th century, began the wonderful resuscitation of medieval learning, which attains its completion in the books and acts of Edward Coke. The political side of this movement is the best known. Antiquarian research appears for a while as the guardian or renovator of natural liberties, and the men who lead the House of Commons are becoming always more deeply versed in long-forgotten records. However, be it noted that even in England a certain amount of foreign theory was received, and by far the most remarkable instance is the reception of the Italian theory of the corporation, of which Dr. Guerrica is the historian and which centers round the phrase persona ficta, fictitious person, folks, persona ficta. It slowly stole from the ecclesiastical courts. It stole from the church. Ecclesia is the Greek word for the called out ones, the church. Ecclesiastical courts are the church courts, which had much to say about the affairs of religious corporations, into our temporal courts, which, though they had long been dealing with English group units, had no homemade theory to oppose the subtle and polished invader. This instance may help us to understand what happened in Germany, where the native law had not reached the doctrinal stage of growth, but was still rather folk law than lawyer's law, and was dissipating itself in countless local customs. Italian doctrine swept like a deluge over Germany. The learned doctors from new universities, whom the princes called to their councils, could explain everything in a Roman or would-be Roman sense. Those princes were consolidating their powers into a, by Englishmen untranslatable, Landeshoheit, something that was less than a modern sovereignty, for it still would have the empire above it, but more than feudal signory, since classical thoughts about the state were coming to its aid. It is noticeable that except in his hereditary dominions, the emperor profited little by that dogma of continuity which served as an apology for the reception. The disintegrating process was so far advanced that not for the Kaiser, which is Caesar in German, but the Fürst appeared as the prince of political theory and the princeps of corpus juris. The doctors would teach such a prince much that was to his advantage. Beginning late in the 16th century, the movement accomplished itself in the 16th. 15th century, the movement accomplished itself in the 16th. It is catastrophic when compared with the slow and silent process whereby the customary law of northern France was partially Romanized. No legislator had said that the Roman law had been or was to be received in Germany. The work was done not by lawgivers, but by lawyers. And from age to age, there remained some room for controversy as the exact position of that corpus juris occupied among the various sources of law, actual and potential. Still, the broad fact that remains that Germany had bowed her neck to the Roman yoke. In theory, what was received were the laws of Justinian's books, Justinian the emperor. In practice, what was received was the system which the Italian commentators had long been elaborating. So they received Justinian's books, but what they really received was the Italian commentators' law. Dr. Guerrica frequently insists that this is an important difference. In Italy, the race of glossators who were sincerely endeavoring to discover the meaning of a classical text had given way to a race of commentators whose work was more or less controlled by a desire for practicality, acceptable results, and who therefore were disposed to accommodate Roman law to medieval life. So now what we're seeing is we're seeing Rome conquer the rest of Europe through legal means via the church. Or author says that especially in their doctrine of corporations or communities, there's much that is not Roman and much that may be called Germanic. This facilitated the reception. Roman law had gone halfway to meet the facts that it was to govern. So Roman law had capitulated some things in order to mold with Germanic law, in order to take over via the corporations. Then again, at a later time, the influence of what we call the natural school of jurists smoothed away some of the contrast between Roman law and German habit. So they massaged it. If in the eyes of an English lawyer, systems of natural law are apt to look suspiciously Roman, the modern Romanists will complain that when and where such systems were being constructed, concrete Rome was evaporating in abstract reason, and some modern Germanists will teach us that nature's right often serve as the protective disguise of repressible but ineradicable Germanic idea. With the decadence of the natural right and the advent of the historical school, a new chapter began. Savigny's teaching had two sides. We're accustomed to think of him, and rightly, as the herald of evolution, the man who substitutes development for manufacture, organism for mechanism, natural laws for natural law, the man who is nervously afraid lest a code should impede the beautiful process of gradual growth. But then he was also the great Romanist, the great dogmatist, the expounder of classical text, according to their true, which must be the original intent and meaning. There was no good, he seemed to say, in playing at being Roman. If the common law of Germany was Roman law, it ought to be the law of the digest, not the law of the glossators or commentators or natural speculators. This teaching, so we are told, bore fruit in the practical work of German courts. They began to take the corpus juris very seriously and to withdraw concessions that had been made, some will say, to national life and modern fact, others will say to slovenly thought and slipshod practice. But this famous historical school was not only a school of historical-minded Romanists. It was also the cradle of Germanism. Eichhorn and Grimm stood by Savigny's side. Every scrap and fragment of old German law was to be lovingly and scientifically recovered and edited. Whatever was German was to be traced through to its fortunes, to all its fortunes, to its fount. The motive forced in this prolonged effort, one of the great efforts of the 19th century, was not antiquarian pedantry, nor was it purely disinterested curiosity. If there was science, there was also love. At this point, we ought to remember, and yet have some difficulty in remembering, what Germany, burdened with the curse of the translated imperium, had become in 6 centuries of her agony. The last shadow of political unity had vanished and had left behind a geographical expression, a mere collective name for some allied states. Many of them were rather states than states. Most of them were too small to live vigorous lives. All of them were too small to be the fatherland. Much else besides blood and iron and song went to remaking of Germany. The idea of a common law would not die. A common legislator there might not be, but a common law there was, and a hope that the law of Germany might someday be natively German was awakened. Then, in historical retrospect, the reception began to look like disgrace and disaster, bound up as a cause and effect with forces that tore a nation into shreds. The people that defied the tyranny of living popes had fallen under the tyranny of dead emperors, unworthily reincarnate in petty pricelings. The land that saw Luther burn one Welsh corpus juris had meekly accepted another. It seems shameful that Germans, not unconscious of their mastery of jurisprudence, should see, not only in England, but in France, and even France of Napoleon's code, the survival of principles that might certainly be called Germanic, but could not be called German without a sigh. Was not a daughter of the Salika, or the granddaughter reigning over the breadth of North America. And then, as might be expected, all manner of cause and parties sought to suck advantage out of a patriotic aspiration. The socialist could denounce the stern and bitter individualism, the consecrated selfishness of the alien slave owner's law, and the Catholic zealot could contrast the Christiano-German law of Germany's great days of Pagano-Roman law, in which the disruptive Protestantism had found an unholy ally. In all soberness, however, it was asserted that old German law, blighted and stunted though it had been, might yet be nursed and tended into bearing the fruit of sound doctrine and reformed practice. The great men were neither dreamers nor purists. Jacob Grimm once said that to root out Roman ideas from German law would be as impossible as to banish Romance words from the English speech. The technical merits of Roman law were admitted, admired, and emulated. Besides histories of German law, systems were produced and institutes. The Germanist claimed for his science a parity of doctrinal rank with the science of the Romanist. He, too, had this theory of possession. He, too, had this theory of corporations, and sometimes he could boast that willingly or unwillingly the courts were adopting his conclusions, though they might attain the Germanic result by the troublesome process of playing fast and loose with Ulpian and his fellows. Happier days came. Germany was to have a civil code, or rather the title at least would be German, a Bürgerschlicht Gesetzbuch. Many years of keen debate now lie behind the most careful, considered statement of the nation's law that the world had ever seen. Enthusiastic Germanists are not content, but they have won something and may win more as the work of interpretation proceeds. What, however, concerns us here is the appearance of Germanistic doctrines led to controversies of a new and radical kind. It became always plainer that what was in the field was not merely a second set of rules, but a second and a disparate set of ideas. Between Romanists and Germanists, and again within each school, the debate took a turn towards what we might call an ideal morphology. They morphed together. The forms of legal thought, the concepts which the lawyers operates, were to be described, delimited, compared. In this work, there was sometimes shown a delicacy of touch, a subtlety of historic perception, of which in this country we having no pressing and need for comparisons, can know little, especially for our notion of an analytical jurisprudence is gathered from Austin's very natural exploits. Of special interest to Englishmen should be the manner in which, out of the rude material of old German law, the Germanists will sometimes reconstruct an idea which is in England needs no reconstruction, since it is in all our heads, but which bears a wholly new value for us when we have seen it laboriously composed and tested. At an early moment in the development of Germanism, theory of the corporation, which gave itself out to be the orthodox Roman theory, and which Savigne had later defined in severe outline, was assailed by George Besseler, who lived to be a father among Germanists. You will never, he said, in effect, force our German fellowships, our German Genosschaften, into the Roman scheme. We Germans have had and still have other thoughts than yours. Since then, the Roman corporation, Universitas, has been in the crucible. Romanists of high repute have forsaken the Savingian path. Hearing went one way, Brent's another, and now, though it might be untrue to say, there are as many doctrines as there are doctors. There seems to be no creed that is entitled to give itself the airs of orthodoxy. It is important to remember that the materials which stand at the Romanist disposal are meager. The number of texts in the digest, which even by a stretch of language could be said to express the theory of corporations, is extremely small. And as implied theories, it is easy for different expositors to hold different opinions, especially if they feel more or less concerned to deduce a result that will be tolerable in modern Germany. The admission must be made that there is no text which directly calls the Universitas a persona, and still less any that calls it persona ficta. Okay, according to Dr. Gurka, the first man who used this famous phrase was Sinibald Fieschi, who in 1243 became Pope Innocent IV. More than one generation of investigators has passed away. Indeed, the whole school of Gloucesters was passing away when the Roman texts would yield a theory to men who lived in Germanic environment. When a theory was found, it was found by the canonists, the cardinals, who had before their eyes, as the typical corporation, no medieval city, village, or guild, but a collegiate or cathedral church. In Dr. Gierke's view, Innocent, the father of fiction theory, appears as a truly great lawyer. He really understands the text. The head of an absolute monarchy, such as the Catholic Church was intending to become, was the very man to understand them. He found the phrase, the thought for which others had sought in vain. The corporation is a person, but it is a person by fiction only, by fiction. Thenceforward, this was the doctrine professed alike by legists and canonists, so lawyers and cardinals. But so, our author contends, it never completely subdued some inconsistent thoughts of Germanic origin, which found utterance in practical conclusions. In particular, the mention one rule, which is a good touchstone for theories, Innocence being in earnest about the mere fictitiousness of incorporation's personality and having good warrant in the digest, proclaimed that the corporation could commit neither sin nor delict, as a dereliction, basically. As Pope, he might settle the question of sin and at events could prohibit the excommunication of an universitas, but as a lawyer, he could not convince his fellow lawyers that corporations must never be charged with crime or tort. Then Savigny is set before us as recalling courts and lawyers from unprincipled aberrations to the straight but narrow Roman road. Let us begin, or bring to mind a few of the main traits of his renowned doctrine. Besides men or natural persons, the law known as subjects of proprietary rights, certain fictitious, artificial, and juristic persons, and as one species of this class is known, it knows the corporation. We must carefully sunder this ideal person from those natural persons who are called its members. It is capable of proprietary rights, but it is incapable of knowing, intending, willing, and acting. The relation between it and the corporators may best be compared to that between pupillus and tutor, or that between a lunatic and the committee of his estate. By the action of its guardians, it can acquire property, and if it is to take the advantage of contracts, it must take the burden also. To allow its possession is difficult, for possession is a matter of fact. Still, after hesitation, the Roman lawyers made this concession. An action based upon unjust enrichment may lie against it, but it must be charged with the delict. To attempt to punish it is both absurd and unjust. Though the state may dissolve a noxious group in an administrative way, being but a fiction of the law, its personality must have its commencement in some authoritative act, some declaration of the state's will. Finally, it may continue to exist, though it no longer has even one member. For at last 3 centuries and more, Englishmen have been repeating some of the canonical phrases, but Dr. Gierke would probably say that we have never taken them much to heart. We are likely, therefore, to overlook some of the points of Savignian theory, which seem serious to those who have not raised convenient in consequence to the level of intellectual virtue. In particular, having made the corporation itself a mindless being that can do no act, we must not think of the organized group of corporators as an agent appointed by a somewhat inert principle. Were the corporation itself capable of appointing an agent, there would be no apparent reason why itself should not do many of the other acts. Savigny is far more skillful. It is not in the agency, but in the guardianship of the Roman kind that he finds the correct analogy. Those who wish to make fun of the theory say that it fills the legal world with hopeless idiots and their state-appointed curators. But if we mean logic, we must be careful to see that our corporation itself, that ding en chic, which somehow or another lies beyond the phenomenal group of corporators, does no act, speaks no word, thinks no thought, appoints no agent. Also, we may observe, and in history, this is important, that this theory might play into the hands of the prince or the princeling, inclined to paternal despotism. Okay, folks, you see it right there. This theory, which has been traced back to at least 1243, now says that this might it might play into the hands of a despot, because a despot can create a corporation that cannot be punished, and the corporations is full of fictitious subjects, i.e. the people who he rules over, but they really don't exist because they are separate from their actual natural persons. I know this is tough to get, but that's what's happened here in our own beloved United States. It's frankly what's happened in England. And that's what I'm purporting here, is that this is why they had to go through England, because England owned the Virginia Corporation. England owned the corporations that conquered the Indies and the trading corporations, and the Dutch and the Spanish. Remember, Spain had conquered the Dutch for quite a while. So what we're seeing, folks, is that we now know what happened. We now know why it happened. And what I'm purporting today and putting forward is that this is how it happened. And now we know why they had to go through England, because they had to force their form of Romanic law, Lex Fori, which is frankly what they have in Washington, D.C., upon the crown colonies. And the only way to do that was through the corporations, because the corporations had been formed before the colonies, therefore their rights superseded the state, and they could stand, the monarchs could stand at least 1 or 2 degrees of separation from that as members or administrators of the corporation, but the corporation really answered to Rome. And so I give you the current situation in England, where the Queen is the Secretary Treasurer of the Holy Roman Empire, a princess. She is a manager of the corporation's assets. She's a paid employee, a figurehead of the Corporation of Rome. And we, as the subjects of that fictitious corporation that has been made real because we are the subjects, the real people who exist as a group within that corporation, which lends the corporation its immortal abilities. And because the corporations were formed before our country, I mean, what I want you to do is I want you to look at Harvard. Look at the universities that were formed by the king. Universitas. Moreover, the modern joint stock company, if it is an universitas, is exceedingly like a societas, a partnership, a Gesellschaft, and this resemblance seemed to threaten one of the securest results of legal science. There are few phrases in the digest capable of perplexing the first glossers, but in the clear words of Innocent Fourth had apprehended the distinction. The universitas is a person, the societas is only another name, a collected name for the socii. Since then, jurisprudence had kept or endeavored to keep the two in different boxes, in spite of the efforts of natural law to break down the partition. In a system of pandecten rect, the universitas appeared on an early page under the rubric Law of Persons. While the societas was far away, probably in another volume, for a partnership is kind of a contract, i.e. have you heard the contract with America? Contract. These are contracts because it's the corporation making a contract with the subjects. And a contract is an obligation. Here, however, was being whose very name of Aktiengesellschaft strongly suggested partnership. And yet the German legislators who had designed it, its mold, had almost certainly meant that it should exhibit personality or legal subjectivity. Though they had not said it in that many words, was it universitas or societas, or neither, or both? Could a mean term be found between unity and plurality? E pluribus unum, plural unity. You see it, folks? What could be the juristic nature of a shareholder's share, as we call it in England? Was it any conceivable form of co-ownership, any real right in the company's lands and goods? Could it be, on the other hand, be reduced to mere benefit of a contract between the shareholder and the artificial person? Ideal walls were rocking and materials interests were at stake. Was it, for example, decent of the Prussian government to tax first in the income of the company and then dividends of the shareholders, and yet disclaim all thought of double taxation? Pausing here for a moment, we may notice that an Englishman will miss a point in the history of political theory unless he knows that in strictly legal context, the Roman societas, the French société, and the German Gesellschaft should be rendered by the English partnership and by no other word. Also, he should know that just as the English lawyer maintains that our English firm is a mere collective name for its partners and displays no artificial personality, so also he will be taught in Germany that the Roman Societas and the German Gesellschaft are not juristic persons. Nowadays, it will perhaps be added that the German Gesellschaft, and the same would be said of the English partnership, shows a tendency to develop towards corporate organization, from which tendency in the extremely individualistic societas of the Romans was wholly free. That is a small matter, but is a great matter. Before the end of the Middle Ages, the Roman word for partnership was assuming a vastly wide meaning, and under the patronage of Ciceronian comparisons was entering the field of politics. Human society should be the partnership of mankind. Civil society should be the partnership of citizens. The origin of civil society should be a social contract or a contract of partnership. If Rousseau writes of le contrat social and Pothier of le contrat de société, there should be and there is a link between their dissimilar books, and the German can say that both discuss the Gesellschaft Vertrag, the one with passion, the other with erudition. Here, then, we face one of the historical problems that Dr. Gurka raises. How came it about that political theory, which went to the lawyers for most of its ideas, borrowed the contract of partnership rather than the apparently far more appropriate act of incorporation? In brief, the answer is that the current doctrine of corporations, the classical and Innocentian doctrine, stood beneath the level of philosophic thought. Philosophy couldn't see it. A merely fictitious personality created by the state and shut up within the limits of private law was not what the philosopher wanted when he went about to construct the state itself. And then political philosophy reacted upon legal theory when the state itself had become a merely collective unit, a sum of presenting existing individuals bound together by the operation of their own wills. It was not likely that any other group would seem capable of withstanding similar analysis. Where philosophy and jurisprudence met in such systems of natural law were fashionable in the 18th century, the universitas was lowered to the rank of societas, but this was the same process. The societas was raised to the rank of universitas. Both alike exhibited a certain unity and plurality, e pluribus unum, unity and plurality, or in plurality one. Both alike might be called moral persons. But in the one case, as in the other, this personality was to be thought of as a mere labor-saving device, like stenography or the mathematician's symbols. What we may call the bracket theory or the expansible symbol theory of the corporation really stands in sharp contrast with the fiction theory, as Savigny conceived it. Though sometimes English writers seem to be speaking of one thing and thinking of the other. I'm going to scroll down a bit. However, despite this tendency of natural jurisprudence, a tendency which seems to have left an abiding mark in the legal terminology of Scotland, the Romanists of Germany had been holding fast the doctrine that universitas is, while the societas is not. A person, when the joint stock company, a new power in the theoretic as in the economic world, began to give trouble. So what we're dealing with, folks, here is our future proofs past. And what we're seeing is they they could not defeat this nation militarily, but they already knew how to defeat a nation non-militarily because they were doing it with England. And once they'd done it with England, what they did is they subjected England's Magna Carta, became subordinate to their Roman law. That they didn't do away with the Magna Carta, they made it subordinate. And they did the same thing to our Constitution. They made it subordinate to the corporation, which is the fictitious entity that supersedes the state, because the corporation is what built the state. And the collective body of persons that are in the state are less important than the fictitious corporation. And it's really sad stuff, folks, but this is what they've done. Now, I've discussed, what they did, when they did it, how they did it. How do we get out of it? That's the next part, is that this is all legality. So there are legal means by which to put the line back on the reel, to rewind the tape. What those legal means are, I think we're finding out now through what Q is doing. But I think we can basically be ourselves prognosticators of a certain type, that we can begin to see where this is going to go, that we have to do away with this Roman corporation, this Roman law, this canonical law, this law from the Vatican, this law from Rome, this law of empiric quality that has subjected us to fictitious persons and corporate legality over our own rights. Making a corporation a person is just absolutely ridiculous and unconscionable to us. But to Rome, it was normal, because they were all headed over by Caesar. And they were planning on conquering the world through creating nation states. And the nation states fed the corporation that was Rome, which gave all his power to Caesar. And so this is the Roman Empire, folks, and this is Roman law, and we've been subjugated to subjects, persons, assets of the Roman corporation. That's why the banks, that's why the universities are involved, that's why insurance is involved, that's why politicians are involved, that's why lawyers are involved, that's why philosophers are involved, that's why Hollywood's involved, that's why teachers are involved, because they're all employees of the corporation. And today I did get something that was, I'm going to stop this share and show you something else briefly, that I wrote a tweet to POTUS today, because, this really annoys me, because this is an example of that which I'm referring to. I went to the White House website today, and it requires that you put in a prefix before your name when you send an email to POTUS. And that prefix is Mr., Mrs., Doctor. That prefix makes you a fictitious person. It refers to the fictitious person with this name and this last name and this prefix and perhaps a suffix. Look, folks, I don't know how this is going to end up, but I do know that it's biblical. And those folks out here who are scholars or believers who do know the word know that all of this was told about. I mean, if you look at the book of Daniel, you're talking about, the mid 6th century BC, talking about this Roman Empire. 6th century BC, folks. 1600 years ago. Excuse me, 2600 years ago. It's amazing. And then you talk about the book of Revelation, that's, circa 95 AD. The Lord told us what was going to happen. He told us that there would be 4 horses of the apocalypse, and the first one would be the Antichrist. We believe it's the Antichrist. We believe that he's going to conquer without any arrows in his quiver, and there's arrows in all of our coat of arms, in the clutching hands of the eagle. That's where the arrows are. We were conquered by the establishment of our states and by our subjugation as bodies in the realm. And these worldly folks, these globalists, they're waiting for their emperor. And the Bible foretells of him too. And what a horrible, horrible being he's going to be. But he's going to appear right out of the gate with signs and wonders and charisma and power and abilities and peace and politics on his lips. But he's really the red dragon. So, folks, we have to prepare. We have to be ready, and we see what has happened, how it happened, when it happened, and why it happened. And now, I believe we have to pray, because what comes next is, what do we do about it? What are you going to do about it? I love you, and I offer this simple prayer. Precious Heavenly Father, bless these folks who have heard this word, Lord. May they be touched by your Holy Spirit, that they have the knowledge of the truth, and that they might come to you and be saved and cleansed of all unrighteousness. May they be, may you forgive them of their sins, Lord, and cleanse them of that unrighteousness, and sanctify them and prepare them for an eternity spent with you. Touch their hearts, Lord, that they might see you. In Jesus' name I pray. Thank you, folks. I do greatly appreciate your time this evening, and look forward to our next conversation. Please prepare your questions for Ralph Epperson and Gary Wayne. They're coming in Saturday, the 16th. It's going to be a wonderful time, and we look forward to visiting and offering up those difficult questions for these gentlemen to answer. Wonderful day. Be well.